I'm going to move now to an opening remarks about the situation in the United States and tell you about the numerous US laws that govern these issues of government access to data. But since it's the Academy Awards week, I thought I should give a few awards and recognize a few people in my life who've been tremendous in my progress. And the first one I would mention is Kevin Mitnick, the hacker. And why? Why? Because in the late 80s, this guy was throwing havoc all over the United States. And he taught me what a breach of security is. And that's when I got started in this business. That's when I got started understanding information security and trying to find out what laws apply to this type of circumstances, this type of hacking, this type of criminal behavior, what is available. And I did so much research on that in 1990 I gave a talk in Paris to a packed audience. We had, I think, 500 people in the room. And that's what got me started. So Kevin, thank you very much for hacking all of these companies. My second hero is Alan Weston, and I have to mention him because he passed away just a week ago. And Alan Weston is one of the founding fathers of the privacy as we know it now. He was very much instrumental in the 1960s in analyzing the issues of consumer protection, the protection of personal data, and the like. And for the following 50 years, he was one of the guiding lines, the guiding souls in the world of privacy. So thank you, Alan, for all the work you've done. And my third hero is Anne Cavoukian. And Anne Cavoukian is the commissioner, privacy commissioner for the province of Ontario, and she's a tremendous scholar, a writer, and thinker, and she is really the person, for example, who thought about the concept of privacy by design and has written a lot about this issue. And why do I mention Anne today? Because Anne said something terrific that is connected to this presentation. She says, whether you have the Patriot Act or not does not matter. There will always be law enforcement methods and techniques that will have access to certain types of information here, there, and everywhere. What you should concern yourself with is the kind of accountability that you will be able to maintain if your email systems goes in the cloud. That's what would concern me. And on this note, thank you, Anne, for showing the way and telling people that don't blame the Patriot Act. It has very little to do with all of this. So why does the Patriot Act have little to do with all of this? Because it's just one of the many laws that we have that were enacted many years ago before even anybody thought about the Patriot Act. So here we have the US Constitution, of course, so 200 years old. But closer to us, one of the most important laws that deals with access to data in the cloud is the Electronic Communications Privacy Act, and you see dated 1986. And actually that law superseded another law that was written in the 1960s. We have the Stored Communications Act, the Wiretap Act, and so on the issue of overseeing information communications with foreigners. There is the FISA, and I'll talk about it, and we have many more. So the Patriot Act is just one of the laws, and it's worse, it's not even a law. It is a compilation of amendments. So again, don't blame the Patriot Act, blame that particular law and the way it is now. The Patriot Act, it was just adding a few commas or a few paragraphs in laws that are pages and pages and pages. This is my favorite slide, so I have to impose that on you, even those who already know what the Patriot Act is, because I think it's very nice to be able to observe, and especially for our foreign visitors, the lack of maturity that sometimes we have amongst our legislators. And I applaud the guy who came up with uniting and strengthening America by providing appropriate tools requiring to intercept and obstruct terrorism. That's what the Patriot Act is. I think it's wonderful. So more seriously, what is the Patriot Act? Again, it's a series of amendments to a number of laws that I'd like to discuss briefly. One of the most important one, most used one, is the Stored Communications Act. And again, it is a very complex law, and I don't have time to discuss it, but I just want to point to you to the complexity of the law by just showing you this next chart. If my friend Pete gets a request, he has to look at this chart, I mean not mine but his, to figure out, okay, what are they asking me? So these are the rules that apply to the disclosure of content. Content is what is inside the file. So it's whatever, your board of directors meeting, it's the recipe for the best pepper steak in the world, that's the content. And so depending on the type of organization that is receiving this request, we have the category on the left or the category on the right. So one is the RCS and the other one is the ECS. So RCS stands for remote computing service, and certain companies fit within a particular definition. And the other one, ECS, is the other one. It's electronic communication services. So you have to figure out, am I an RCS, am I an ECS, am I both? Because we have companies that actually provide both services. And then once you get that, you say, okay, so let's look at the column on the right. Is what they want, has it been stored for more than 180 days or less than 180 days? Because again, we have a different rule. So again, we don't have that much time. I just want to point to you to the enormous complexity of these laws. And so when I see them summarized in 2 lines by someone who has not even opened a book that contains the law, I cringe. So we have laws for content, and then we have different provisions for non-content. And one of one of the aspects that's very important that we are discussing today is the notion of what does it take for a law enforcement person to ask for this content or non-content. They need to ask permission. And how do we ask permission? They have to explain why they think that they should have access to that. So depending on the type of permission and the type of content or not content or more than 180 days or less, they may be required to obtain a warrant or a court order or a subpoena. So since my friend Jim Dancy is here, I have to quote him because that's the best definition I've ever heard of a subpoena. What's a subpoena, Jim? A subpoena is Latin for a judge has never seen that. So that means that it's a very, very low level type of requirement. You don't have to prove much. On the other hand, if you are required to present a warrant, the warrant is a document that requires the applicant to provide a number of details about the type of information he's seeking, why he's suspecting that this information is going to be able to solve a particular issue, and so on. So you have a very detailed set of information required. The thing that I want to show you is, going back to my prior slide, is again, whether you have a warrant or no warrant is going to have a consequence, because in some cases the recipient of the request is when the government made that kind of request, they must notify the person who is the subject of the request. Sometimes they don't. And again, that depends on warrant or no warrant. Again, I want to confuse you totally so that you leave the room saying, my God, this is so complicated. How can my friend Pete sleep at night? So that's one law. Another one that I wanted to show you is the FISA. FISA is the Foreign Intelligence Surveillance Act. And again, as you can see from the date, FISA was enacted in 1978. So again, what does the Patriot Act has to do with this? It made changes, but FISA was already there. FISA is a law directed to the collection of information or data or communications related to a foreign power. And again, we have pages of definition. To put it simply, what's a foreign power? It can be a foreign person, it can be a foreign country, the idea is to gather information related to terrorism, national security, and the like. And so you have a number of definitions provided in this slide. I highlighted the significant purpose because that's one of the changes of the Patriot Act. So there was a provision that defined what is FISA, and the prior definition was that the purpose of the investigation had to be the primary purpose of the investigation had to be to find evidence, and then that triggered the application of FISA. So come the Patriot Act, and these two words have changed from primary purpose to significant purpose. The conclusion from our standpoint as lawyers is that, of course, it raises the bar or lowers it, which way you want to look at it, but it makes things easier for the government in its investigation, because there is less of a burden to show, oh my God, this is really so big, we need to do it. If the purpose of the investigation is only a significant purpose, then there may be investigations that are at the edge of not being allowable. So FISA, again, is a very, very complex law, and it provides for a system of running an investigation a little different than what there is under laws such as the Stored Communications Act. In this case, the warrant, the search order, and so on that was requested from a judge now has to be obtained from a FISA court. So there is a specialized court that deals with FISA matters, and so it has the requirements under that court are more friendly, if you want, to the law in investigating, the law enforcement investigator, and but nevertheless they have again a list of things of statements to make that is pretty long, and so you have here in the bullets, I hope you can see them, the requirements for that the law enforcement person has to demonstrate when seeking this authorization. But the point I want to make is that, again, the concept of, oh well, the government shows up and knocks at Pete's door and asks for things, that's not how it happens. There is a number of steps, a number of requirements and authorization and prove this and show that and so on. That is the norm in these investigations, whether it's the FISA type investigation or whether it's the stored communications type investigation. FISA was amended recently, and again it made it a little more liberal for the U.S. government. The amendments were adopted in 2008, and they were extended just at the end of December. So we have, if you hear about the FAA, that's the FISA Amendment Act, that amends the pre-existing FISA law, and again that provides a little more freedom to the U.S. government. The reason why they were enacted was actually because there was a number of investigations that were conducted, and there was a thought that the U.S. government should be reined in, and that the nature of the investigation should be written down, that the rules should be more explicit. I'm going to move along because I want to have a lot of time for the discussion with the foreign lawyers. Another concept also that has been discussed with the Patriot Act is the concept of the national security letters. So it's the notion that the government can ask certain categories of companies, and they are listed here, financial institutions, telephone companies, consumer reporting agencies, for certain types of information. And again, these laws have been in place for a long time. What the Patriot Act did is add one category of NSL, but these requirements have been in place since the 1980s. Trying to move along and bring you to the meat of our presentation here and our discussion with the foreign lawyers. What happens when the US needs to have access to information that is located in a different country? Well, guess what? The countries, they love to cooperate with each other, and they've done that for many years. And we have treaties and conventions, and they really talk with each other. And again, you don't have the FBI agent going on his 747 or whatever, 767 now, to Paris to grab data. They talk to each other because they have the treaties, in particular something that is called an MLAT, it's Mutual Legal Assistance Treaty. So there are many treaties between the countries where they help each other. There is also a convention on the same issue to which most of Europe is member, and that has been signed as well by the United States and Japan. So that's the convention listed there. And through these conventions and these MLATs, that's how the countries speak with each other, interact with each other, make commitments. And for example, in the Council of Europe Convention on Cybercrimes, actually the countries have made a commitment to address this type of investigations in a certain way and to regulate these investigations. So there is a structure. And the thing that bothers me very often when I read the press about the Patriot Act is that it makes it look like it's the Wild West and everybody goes grab documents. And that's really not what I see as a lawyer. The number of pages and pages of laws and conventions and so on that is on the books and is being applied is tremendous. Finally, as my segue to the second half of the presentation, I'd like to show you two tables, and they are in the materials, in the thumb drive, so you can see them. The figures are a little bit old, but I think that they should give you an idea of what is happening. And so this is a comparison. I mean, I drew the table collecting information from different countries and ended up with that. And so that table shows the number of interceptions. Because, oh yeah, I forgot to tell you, not only do we have all these laws and rules and regulations and amendments and so on, the judges who receive these requests for warrants and court orders and so on actually have to make reports. And the people who make the requests, and the law enforcement agencies who make the requests, also have to make reports. And these reports are compiled, and they are sent to Congress, and they are published on the internet. And that's where I got some of my figures, those for the US. That's where I got them. This is public information. And the other countries, I'm sure we'll discuss that with our friends, have similar requirements. You can find publicly the number of investigations, the number of wiretaps and so on that have been conducted by the local government. So what I want to point you in here is the numbers for interception for the US. And then, I love my friend Raphael, and he's going to tell you everything about it. But look. And I have another one. That one was by the Max Planck Institute, and they were counting, because numbers don't mean anything. We are, whatever, 350 million people, and Italy has 60 million. You have to compare apples to apples. So this one compares the proportion by inhabitants, the number of inhabitants, and again, Raphael, you're on the spot here. So I thought we should ask our friends, I should ask my friends from the Lexing group to tell you all about their life in their country with their laws.